Hi, this is Brad Wewell. You are coming in to do your update meeting for us to give you a new trust and new powers of attorney and all kinds of new, frankly, and exciting things. We're going to see you at your update meeting, but I thought we would do a little video to kind of get you the information sooner than later. And by having the information sooner than later, by watching this video, we actually be able to save you time when you come into our office. We don't mind seeing you. We don't mind spending as much time with you as you would like us to. But we're realistic enough to know people would rather not spend as much time with us if you don't have to. So here is what we're going to cover for the most part at the meeting, and I think you'll like it. We have increased the remarriage protection. Okay? We're always concerned about this. We see this happen more and more. One of the new provisions is if you remarry, great. You probably know this. You're going to be required to get a prenup. And the prenup is going to require your new spouse to waive their right to ever sue you for their attorney's fees in a divorce. So people get divorced, even a lot of people, frankly, who get remarried after the death get divorced because they kind of went into it sometimes with not as clear a thought as otherwise, and they end up in a divorce, and now your new spouse is never going to be able to sue you for their attorney's fees. And attorney's fees are probably the most expensive part of divorce. We want to eliminate that possibility. We have heightened confidentiality provisions. A lot of people call here, hey, I'd like to get a copy of Mom's trust, Dad's trust, this, that. We're not passing these things out like candy. So we have heightened who gets it and who doesn't get it. And we're happy to go over those provisions when you come in. We have clarified the removal process for a trustee. It may be a situation where the people that are acting on your behalf after you can't act, maybe they become disabled. So it's easier now to get rid of a disabled trustee than it had been before. We have a philosophy on disability, and this basically says to your loved ones, look, I know I want your help, and frankly I'm going to need your help if I'm incapacitated, but I also understand you have a life. So please devote as much time to me as you can, but I also understand that you have other things you have to devote your time to, and I appreciate your helping me, and I understand that you're going to do other things in your life too. We also have a philosophy on distributions, which says, hey, to the greatest extent possible, I want whatever goes to my loved ones to go to them protected from a divorce, from a lawsuit, from a bankruptcy. And this will help first to let your loved ones know, but also if there is any litigation, this tells the court what your goal was and will help uphold the validity of any of the planning we've done for you. Long-term care benefit enhancements. So nobody knows the future, and things in the economy look really good right now, yay. But we've all lived long enough to see the economy go the other way. If any of our clients ever end up in a situation where there are some government benefits available to them, then the new trust provision says, hey, if they're available, go get them. Okay? Don't want to have to spend every dime and dollar of my estate on care if there are other things, other avenues available, perhaps through some government benefits that we can take advantage of. Storage of personal property on disability. So we've always had a provision that says, hey, if I'm gone, here's what I want you to do with my stuff. It usually consists of leaving a list of who you may want to get your stuff and then some other provisions after that. But we really didn't have a provision on what to do with my stuff if I'm still alive but incapacitated. So now we do, and it really tells the trustees, store it. Store my stuff, because I may come out of my affliction and I'm back to normal and I don't want to find out my couch has been sold, my TV is gone, whatever. So we're going to store it until you recover, and then of course, if you don't recover and you pass away, it'll go according to those provisions. Funeral fund advancement. It happens that people die and the family is there and the funeral home says, hey, it's going to be X to pay for the funeral. Well, we don't have time, your family won't have time to start a little trust administration before somebody can write a check. So this says the trustee can always write a check out for funeral arrangements sooner than later, right away if necessary. So we want, of course, that taken care of properly and promptly. The significance page and personal property distribution. Still in the theme of property. there are things that happen with your property that you're going to want to have to happen to your property. And I want this ring, I want this watch, I want this car, I want this firearm to go to this particular person. Great. What the heck do they know about what they're getting? So we've changed the title of this to talk about heirlooms to make it more relevant. And we've had it before, but we're bringing everybody's attention back to this thing called the significance page. And the purpose of the significance page is you tell the story of the item for your loved ones, okay? This is my wedding ring. This is not my original wedding ring. This is one I bought online. No kidding. My original wedding ring is in my wife's jewelry box because, and we got that when we got married and had no money. And here's where we got it, and here's why we didn't have money. Tell the story, okay? Your loved ones want to know the story more than they want the item. And if they have the story with the item, it'll make the item so much more powerful and so much more important. In-law issues are addressed. So in-laws still in this personal property thing, we really want to discourage a son-in-law or a daughter-in-law from getting involved in the division of your property. That is where fights can break out, and it's a very delicate thing to begin with, so we have language to discourage them from getting involved. Medical power and financial power coordination. So we have your medical agent who's making medical decisions, and we got the person with the checkbook over here going, hey, what's going on over here, and hey, what's going on over here. So now we have provisions for them to communicate better with each other, so we're not spending money that we don't have to spend. Everybody's on the same page. Cost savings for special need beneficiaries is another thing we're upgrading and updating. You may not have it. A lot of people have special need beneficiaries. It's a child or grandchild with autism, and maybe a child or grandchild that's been in an accident and now have head injuries. And those are expensive things to administer. You've always had a special needs trust in your trust to say, hey, the money that's going to the special person they get, but they only get it carefully. There is a low-cost trust company here in Austin called the Arc of Texas Master Pool Trust. Your trustee now has the ability to transfer those assets to that Arc of Texas Master Pool Trust where they can be used and benefit your loved one at a very, very, very low cost. So we've added that possibility to save money. Litigation and divorce expenses allowed. So if I'm your heir, and thank you very much, by the way, and I've got the money that you left me, and it's a little trust that I can spend and enjoy, but I can't use that money if I'm getting divorced to defend myself, or if I'm getting sued to defend myself, that's not doing me a lot of good. Your trust says that if one of your loved ones, one of your kids, whatever, is getting divorced or is getting sued, they can use the money you left them to defend themselves in those things. Student loan repayment. How many kids have got large student loans? Again, they can use the money that they've inherited from you to pay back their student loan. It wasn't clear, it's clear now. You are going to get the latest, greatest durable power of attorney, financial power of attorney that the legislature has come up with. We've added a lot of things to it. Bear in mind that a durable power of attorney is what we're going to use to manage your retirement accounts if you're incapacitated. The legislature changed it every year. They change it every other year, and they change it every other year. So you're getting the newest, latest, greatest version of that. We have now, of course, the ability to transfer into your trust digital accounts and manage digital accounts. And so many of our clients bank online, have investment accounts. They don't get paper statements. They just get it online. And so we have added things to make that smoother, and we're going to give you a cool little tool for you to be able to record your passwords and record your usernames so that if you're tragically killed, somebody knows what they are or knows how to access them. And then last but not least, and this is something that frankly I think you'll find very helpful and maybe the best part about your update, is we have a brand new sheet. It's on yellow paper. It'll be at the very front of your binder that says what to do when somebody dies. What do you do? It's the most common question we probably get from clients. And so this is about a 24, 25 point checklist on what to do. And you'll like that. On the flip of it is something about protecting your identity if you die from identity thieves, which is a huge problem too. So you'll get that when you come in. We are looking forward to seeing you, and we're going to have a great meeting. If you have any questions between now and then, contact your funding coordinator. They'll be able to help you. If you ever need to talk to me, please give me a call. Thanks. Look forward to seeing you.